Hi, everyone. My name is Anna. I'm here with the You interview on episode 2, back again with Mr. Andy Conn from the Conn Law Firm. Welcome back, Mr. Andy. How are you doing today?
Thanks. Yeah. Thanks for having me back on, and I'm feeling good. How about you?
I'm doing good. Thank you very much for asking. We're very happy to have you here. Today, it's going to be a very specific focused episode. We're very excited about the prospect of sharing this type of information with future clients and just listeners in general, because today we're going to be talking about what happens after a car accident in Savannah. So we know that Andy has spent his career trying cases that most attorneys wouldn't touch. We're going to cover everything from what to do at the scene to how Georgia's at-fault based insurance system works, filing deadlines, dealing with insurance companies, and when you actually need a lawyer who will take your case for court, litigation, whichever it is. If you have ever been in a crash in, let's say, Chatham County or anywhere in Georgia, this episode is for you. And we have the amazing blessing that our questions are going to be answered by Andy. So, Anna, let's jump right into it. Let's go to the scene. So picture this, guys. We're at the scene. We've just had a car crash. God forbid. We're anxious. We're nervous. We don't know what to do. What should someone do immediately after a car accident in Savannah to protect their claim?
It's obviously very easy for me to give advice sitting comfortably in this chair, not being in the situation that you just mentioned. But obviously for folks that are in that situation, it's really scary. It's oftentimes stressful. Sometimes you're in pain or you don't know what's going on medically. And so, while I can appreciate being in that fight or flight mode, oftentimes you might not always make the right or wrong decision. One thing is there's a couple things to keep in mind in those scenarios if you do intend to file a claim or potentially a lawsuit down the road. First thing is you want to make sure that you're okay to some extent. Make sure that you don't need immediate medical attention or need to be rushed to the hospital. If that's not the case, then you obviously want to just assess the situation. Take a look at the car damage, take pictures of everything. Inevitably, EMS personnel typically will arrive to the scene. And in those instances, you want to make sure that the EMS understands everything that's going on with you. You also want to make sure you call the police if they haven't already been called. Again, oftentimes someone will witness these accidents, and so the police will get called, oftentimes without you having to. But in the scenario where they're not already called, you want to make sure that you call them, report what happened. And when they get to the scene, you want to make sure, even though it's going to be, again, very scary, you want to try to report to them as accurately as possible what happened and what you saw. And so those are sort of the main first things that you want to take care of in these instances.
Perfect. I feel like me personally, myself, Anna, if I were in a car accident, which we've stated I haven't been, I don't really think that my first instinct would be to check on myself. And I think it's a good reminder to let people know, hey, within the adrenaline rush, maybe you're going to feel it, maybe you're not. I feel like most likely you won't for the shock of it, but it sounds like such a little thing to mention, but thinking in a, like you said, a very comfortable environment, I'm sitting at home, I'm not really in any type of rush. I think a lot of people forget, hey, you can check on yourself. And within that midst, would you recommend that initial exchange of information with the other party at hand during a car crash? Or would you recommend for there to be a little separation and not talk without any type of attorney present or any type of officer or EMS or just a one-on-one interaction?
Yeah, I mean, obviously the ultimate legal claim is important, but we're still human beings, right? And we still want to act like human beings and not let the legal case, get in the way of being a decent person. And so I always would recommend checking on the other person, making sure they're okay. Even if they're the person who caused the wreck to begin with, we still want to be decent human beings. We still want to check on them to see if you can help them in any way. When it comes to the what happened sort of things, I'd probably steer away from those sorts of things with the other driver at the scene. But yeah, when it comes to talking to them, you can be a human. You can talk to folks, make sure they're doing okay. And one thing too, I meant to mention a second ago, and you said this, it's such a good point, is the adrenaline is oftentimes running. Had a client recently it's a close personal friend as well, and she got in a wreck, and she called me from the scene of the wreck to sort of ask these questions. What do I do? And I asked her if she was okay, and she said she didn't really know, even though she was in a pretty bad wreck. She didn't know if she was okay or not, but she said she felt okay. And she must have had some high adrenaline running because she found out she'd broken her wrist the next day. In that instance, while she was there on scene in the stress and the adrenaline, she didn't even know that she was pretty significantly injured. And again, that's due to adrenaline. So a lot of times what insurance companies like to do is to point to you saying at the scene to EMS personnel or police personnel that you're okay as some indication that you're not hurt or that you're not entitled to some form of compensation. As hard as it is, with that adrenaline running, I'd still just really encourage you to stop and think what hurts and make sure that you're reporting that to any of the responding first responders at the scene of an accident.
Imagine, I've never broken any bones on my body, but I've heard that it's a very painful situation to be in. And that type of adrenaline rush to be hitting you so hard that you're not aware that something is broken. It's such an important thing to mention because, like you said, with that example of your personal friend, anything could happen. You could be in pain and still feel so anxious and stressed out about it that you're not really connecting the dots and thinking about it. And it's such an important thing what you mentioned about the insurance company, that even if it could be taken out of context, what you say on the moment. And I think we can mention witnesses, for example. Would you consider that it would be a good step to take if you are able to? We're talking about a situation where your friend was, thank God, conscious. She was not taken out by EMS. She was still there. She had time to call you. But how could we work around the witness situation? Like you said, even sometimes you may not be the one to call the police department, EMS, ambulance, 911, whichever, but there are people to witness the incident. How would you, or what would you recommend to do about those people that were able to see what happened?
Yeah, again, and a lot of this is with the benefit of being in this comfortable place right now, and that's more difficult at the scene of an accident. But absolutely, not only talk to witnesses, but get their information, because sometimes you get lucky and the other driver is honest and says, I ran the red light or I ran the stop sign. But oftentimes that person has a self-interest in not telling the truth. And so it becomes a he said, she said sort of thing. But if you have objective witnesses who saw the accident, who aren't your friend or related to you, but report that you were the person who actually were acting prudently, it is incredibly important to get those witnesses' information. And I'll give you an example. I have one case right now that we just filed a lawsuit on where it is a he said, she said in some ways, and there were multiple witnesses at the scene. One of those witnesses happened to be from Spain. And so the responding police officers did interview the person, and he did say that the other driver, not my client, is the person who was at fault for the wreck. But because he was from Spain, the police did not take down his information. So we don't have this particular Spanish individual, this witness who corroborates what my client says. We don't have his information. Doesn't mean we don't have a case. There's still other investigations and forensics that we can piece together with experts to show that my client was not the person at fault. But it would have been a lot easier and a lot cheaper to have a witness who would relate exactly what happened. And just because the police record that statement. And so even though we can forensically go in and have these experts, it's a lot cheaper and easier to have a witness who corroborates what you say, who can testify. Even though that the police might have recorded this statement from this Spanish individual, that doesn't make it admissible in court. You need the witness to actually be there to record his sworn statement to be able to have that admitted in court. So really important that you speak with folks if you're able to. Understand sometimes you're not, sometimes you're too injured, sometimes you're too stressed, but to the extent that you can, get witness statements, get their information so that your attorney can help you manage those witnesses.
What a great example. And it's such a particular example as well. The fact that just because this person was from Spain, he was not from the United States, it can be such a delicate situation. I would also like to add this correlation, but while you were explaining to this, I got to thinking, how about the admission of fault? we were mentioning and speaking about, you can be a human, you can be a person trying to understand and see if the other person is okay. I feel like some people generally just go, oh my God, I'm so sorry. Are you okay? And that I'm sorry is that admission of I'm apologizing because I was at fault. I did something. And usually we don't take it as I'm admitting that this was my fault. I'm so sorry this situation happened. I'm making a
Right.
notice of it. And I feel like it's an instinct to be, oh my God, I'm sorry. Are you okay? Or, oh, I'm so sorry. And that admission, and that maybe not admission, but saying that I'm sorry. Is that something that could be used against a client and out of context, or how can we manage around that situation?
So the short answer is maybe be used against you. There are rules in Georgia that where sort of these sentiments of sorrow at times are not actually admissible at trial. It's still a good idea, though, to the extent that you're thinking about it, to be careful what you say in these instances. But like you mentioned, at the end of the day, we're human. I know my mom is one of the sweetest ladies in the entire world, right? And I know for a fact if someone clearly ran a stop sign and hit my mom and she was driving under the speed limit, she would still go up and apologize to him, to that person, even though she knows she didn't do anything wrong. That's just her nature. And I know if she listens to this podcast, she's still going to do that at the scene. So it's a good idea to try to avoid that. But to the extent that, you're just a human, don't beat yourself up. That's why you should hire an attorney in these sort of personal injury cases and car wreck cases, so they can help you manage the human element and help explain to an insurance adjuster or eventually to a jury why your sorry was just your human nature and not an admission of fault or guilt.
It makes a lot of sense. It's at the end of the day, for people, some are so much sweeter than others. And I think it's just the conscious effort of being, hey, this is an accident. There are certain steps, but at the same time, I feel like it's such a difficult thing to go through. And I say this, come in my house, no injuries, my car is not wrecked, everything is fine, essentially. But it's such an important thing to mention. And I think we can then jump onto my next question. When it comes to a car accident in the state of Georgia, is there a legal requirement for a report? Am I legally required to report a car accident within the state of Georgia?
The short answer there is depending on the type of property damage or whether there's injuries at the scene. Almost always, though, in today's day and age, your property damage is going to be at or above $500, which is the standard for reporting in the state of Georgia. It's always a good idea, though, and usually the best idea is to call the police officers, like I mentioned before. Hopefully, the police will have availability. They'll respond to the scene, and they'll fill out an accident report that will be filed. And if that happens, then you don't have to do anything else. There are certain instances, we saw this a lot during COVID. It's become less of an issue now, but sometimes the police just won't be able to respond to an accident. If that's the case, then you still have reporting requirements to the state, even beyond just making that phone call. It's what's called an SR-13 form. And in that form, you can go online and fill that out, but you have to do that within 10 days of the accident. So these days, the sort of rare instance where the police do not respond to a call, you want to make sure that you're still doing what you're obligated to do under Georgia law. Whether you're the person who caused the wreck or you're the person who got hit by someone else, you have an obligation under Georgia law to report that. And so you want to be very careful, make sure that you're dotting all of your I's, crossing all of your T's. And again, a good attorney will help you walk you through that process if it's necessary.
And what about if we are not able to file that form? SR-13?
Yeah, SR-13.
Would anything happen if we're not able to file that form, or is it something that either police enforcement or our attorney are going to guide us through in order to do it?
Yeah, so there are some exceptions, right? If you're incapacitated, let's say you get hit at the scene and you're in a coma for 11 days, well, you couldn't possibly fill out an SR-13 form when you're in a coma. Likely in that instance, there's going to be a police report that obviates you of that obligation, that happens because you're in a coma. But to the extent that you wake up 11 days later and find out that there wasn't an accident report filed, then you would still have some obligation to do that within 10 days. Now, like you mentioned, the best thing to do is to call an attorney and make sure that the attorney is aware of the situation, the facts, and let them help you manage that process. Especially when you're in a catastrophic injury type situation, the last thing you want to be doing is being worried about paperwork, being worried about contacting witnesses and insurance adjusters and all these different things. You need to be focused on your health and getting better. And so hiring a good attorney who's knowledgeable and who has the experience to do these sorts of things is hugely important, just for the main thing, out of a peace of mind.
And is this SR13 form separate from a police report? Is it something that we file together, or is it within the same documentation that we're going to be needing, or is two completely separate instances?
Well, so an SR13 is just the accident form. That can either be filed by police or by an individual. If the police come out to the scene, let's say someone calls the police, they come out and they fill out the accident report, that is actually the SR13. So if the police do that, you don't have to then go independently fill out another SR13. Really, the only time where you have to go online and fill out that SR13 form is in an instance where the police either weren't called or didn't respond to the scene of an accident. Then you would have an obligation to fill out that form and submit it to the Department of Driver Services.
And in those situations, maybe police when it's not called, like you said, and I'm not able to fill it at the moment, for some reason, it's my first accident. I don't know that I need to fill it out. If I was to fail on that requirement, is there any type of repercussions that could come apart from not being able to have my accident claim reported or anything? Would I be going through anything else?
Yeah, possibly. I mean, it is technically legally a misdemeanor not to report an accident in the state of Georgia. Okay. Now, whether or not they're actually going to prosecute that technical misdemeanor crime, usually that's probably not going to happen, especially in the case of someone who was seriously injured in a car accident and is unable to do so. But there are potential complications to doing that. And so it is a legal requirement to report an accident in Georgia. The other sort of, although it doesn't have criminal legal implications, the other reason it's important to report an accident is because you want records of this. Mm-hmm. If you have a personal injury claim, to show to the insurance adjuster and to the insurance company, because if you call up the insurance company and say, I got in a wreck 6 months ago and I want to file a claim, the first thing they're going to ask for is an accident form, the SR13. And if the police didn't respond and you didn't fill that out within 10 days, then you might have an insurance company dispute whether the thing that happened ever happened to begin with. Mm-hmm. And beyond your legal obligations, you want to be filling out this form if the police do not respond, because it's so important to document what happened for future claims.
Makes absolute sense. I think the biggest things worth mentioning and taking a note of is that record, that documentation record, and being sure that your claim is going to be secured by having all of the steps needed. And I think, and it's also a great thing to mention that it can be done within those 10 days, because you were taken out by an ambulance on that first instance. I wouldn't be thinking about filling out a report if I'm in the heat of the moment, and maybe that's me, but I don't think I would personally be thinking, I need to file my claim, I need to fill out this report. But it gives you that little time and space for you to calm down. I know that I'm the type of person that if something were to happen, I would like to take a day to breathe, understand what happened, and then be like, okay, what is it that I need to do? So it's such a good thing that at least they give you that little space of time for you to calm down, get medically checked. And we can jump into also that topic, the medical care after a crash. Is there any specific order of things on how it should happen? Where should someone in Savannah go for medical care after a car crash, even if they feel fine? That mention of the adrenaline of saying, I'm okay. I know that a lot of injuries, sometimes specific type of injuries in a car crash, they may not show up for a couple of days, where you suddenly wake up and you're like, what is this? what is this? Is this hurting? This feels off. I feel my head feels a little foggy, and it's like a tumbling sensation of this started, but it happened 3 days ago. So I'm not sure if this is related to my car crash. Is this related to something else? What would the necessary steps for medical care be after a car incident?
Yeah, due to that adrenaline that you have at the scene, no matter what the circumstances are, post-accident is always scary. It's always high adrenaline. I always recommend that you go get checked out as soon as possible. Even if the ambulance, you decide not to take the ambulance to the hospital, that's okay. Either if you're able to drive yourself to the emergency department or have a friend or loved one drive you to the emergency department, I always recommend doing it that day, even if you're feeling okay for the reasons that you just mentioned, because you don't know what was jarred loose that you're not feeling because of adrenaline or because of anxiety or all these different things. And so you want to make sure you get checked out. The biggest reason why is not for your legal claim. It's to make sure that you're okay. And so I always recommend getting checked out at the emergency department. That case that I mentioned earlier, where my client didn't know whether she should get checked out or not because she felt fine. She got checked out. They did an x-ray and found that she broke her wrist, which again is objective. No doubt about it that this broken wrist happened due to this wreck, but she didn't even feel that during this event. So I always say get checked out. Now, even when you go to the emergency department, they basically are only checking you out for sort of the broken bones and immediately life-threatening issues. And if you don't have either of those two things, they're going to discharge you. Even though you might still have some pretty significant objective injuries, that's not their job at the emergency department to check you out for everything that you could be going through. So I often have clients who go to the emergency department and they do x-rays, there's no broken bones. And even though they've got neck or back pain, the emergency department typically will discharge them if they're not having any significant life-threatening emergencies. And so even after the emergency department, you want to get checked out by at least a general practitioner. And if you have neck, back pain, shoulder pain, knee pain, any sort of body pain, you likely want to see an orthopedic surgeon of some degree, because they're going to be able to actually do a full evaluation on you. Oftentimes they'll order MRIs, which is not something typically ordered by the emergency department. And MRIs show us things in much more detail that are going on in our body that an X-ray can't show, and that an emergency physician is not going to be able to understand. So even after that first day, in the days and weeks following an accident, I would definitely follow up and see and make sure that what's going on. Anytime you're seeking medical treatment at the emergency department with your family physician, with an orthopedic surgeon or a neurosurgeon, you want to make sure that you're telling them everything that's going on, because you might have 10 different injuries going on, but if there's only a lot of times you report the thing that hurts the most. What insurance companies like to do is say, you only reported that one thing. These other 9 things must have not been going on. That's not how we work as human beings. We try to work on the thing that is at the top of our mind. So you might only work on the neck pain that hurts, even though you have back pain and shoulder pain and knee pain. But I would encourage you, tell your doctors at every visit everything that's going on with you. Nothing is too small. Make sure that they know it so that they can document it for the record, so that the insurance companies can't use these tricks to avoid paying you the compensation you deserve.
And when it comes to the medical treatment plan, I want to dive a little more specific when it comes. For example, when you mentioned neck, shoulders, knees, the pain, usually when it comes to starting, for example, for you to be seen by an orthopedic, let it be orthosurgeon or just a general consult with an ortho doctor, what would you say about that medical documentation? Most of the time, and I can finally say something from experience, when it comes to the medical treatment plan, one person, like you said, usually we focus on what's hurting the most. So I have a back pain, and while also my knee was busted and my wrist is in pain, I cannot handle the pain of my spine. And then I went to my PCP. They referred me to specifically a spine ortho doctor. The spine doctor just, of course, checked my cervical spine, and I was referred to MRI and injections and physical therapy, pain management, and up until pain management, where I have to do a very specific type of movement. That's when I mentioned, oh, but I can't do that because my wrist hurts. That's when the doctor will be like, why wouldn't You mentioned that before, and we've been working for 2 to 4 weeks in this past days. Now you mentioned the wrist. Now I have to go back to my PCP. And I think a lot of people don't know that when it comes to orthopedic medicine, a cervical spine ortho doctor, it's not going to be able to see your wrist. Wrist is not going to be able to see your knee. Knee is not going to be able to see your shoulder. So you're going back and forth between this type of ortho and other type of ortho. And that's when a lot of people get confused. And as a attorney, you call them just to check up on, hey, how are we doing with our medical treatment plan? How are our documents? And that's when you realize people get confused. Oh, I thought I was going through ortho for my wrist, but I went for spine. So I missed this one and now I'm not getting treatment for this one. And now there's a gap in my treatment that is clear within my records. When it comes to that documentation trial for medical records or that linking of injuries within your claims, is there any type of advice that you will give your clients when it comes to understanding what is going on with them and the importance of attending their medical treatment plans?
Yeah, so a couple of things. Definitely the point I made before is the most important. You need to report every single thing that you're feeling at each medical visit that you go to. Even if you go to a spine doctor, I want you to tell the spine doctor about your hurt knee and your hurt wrist, in addition to your neck and back pain that they're evaluating you for. Even though, again, when we operate as humans, we're not always trying to get everything documented for a legal case. And so it's understandable that people at times will not report some of these things to their particular doctors. But insurance companies, again, are going to use that to try to avoid paying you what you deserve. Now, for jury trials, that's a different matter entirely. I think jury trials, you have 12 human beings who understand why you might not report something. And so when it actually comes to jury trials, I'm less concerned with the quote unquote gaps in treatment. But if you want to settle your case without filing a lawsuit, or if you want to settle your case after filing a lawsuit before a trial, those gaps in treatment do matter. And so it's super, super important that you're reporting everything that's going on at every single visit to any medical provider.
Is there a problem within my gap in treatment? We're humans. Of course, I'm going to get confused if I've never been in a situation of, do I mention to my spine doctor that my knee hurts? What is he going to do about my knee if he's spine? That creates a lot of confusion, but it's such an important thing to mention. Whichever doctor is treating you, taking care of you, giving you any type of recommendations or anything, the importance is because the entire body is connected. What does my spine have to do with my knee and my wrist? But it's an entire system. So I think understanding that your documentation trial, your medical plan, the importance of being open about everything that's happened. Because I know sometimes if I'm feeling a little bit sick from multiple things, I'll be like, I'm fine. It's just my head hurts, but then my entire body hurts as well. But I don't want to be this bother nuance type of situation. But I think in a note of the insurance constant need to prove something is different for a client. It's such a very important thing. And that now that we've covered what to do at a scene, when to call 911, what the documentation for medical insurance and accident claims, essentially document everything, get the medical care, even if you feel fine.
One other thing I'd mention too, I think is really important. I see this a lot in the medical malpractice context, but it's also really important in the car accident context. You are your own best patient advocate. No one is going to advocate for you like you. And so we see it in the medical malpractice context all the time where a doctor or a nurse or some other medical professional doesn't take something you're saying seriously. And sometimes it takes you advocating for yourself and you demanding to have some sort of diagnostic testing to be able to heal yourself. And oftentimes that's where medical malpractice cases happens, is the doctors and nurses don't do that. In the car wreck realm, you want to be your own patient advocate and making sure that the doctors and nurses understand everything about your condition. Advocate for yourself. Say, this piece of my body hurts. I want a scan. Or I want to go, I don't want to feel this bad anymore. Please prescribe me something to help me with this pain, or injections, or sometimes ultimately you have to undergo surgeries to fix the pain or the issues that you're suffering from. But the only way you're going to get that help is if you advocate for yourself.
100% agree about being your own and biggest, strongest, number one advocate. And it's a great thing that you mentioned. I don't think a lot of people understand that you are able to request things just because you want them, because you feel like you need them. Just because they didn't prescribe this or that doesn't mean that you don't feel your own pain. You understand your own body and you're able to say, hey, I want this, I'm requesting this, and that's it. Because I feel like this is right and I want it. And no one's going to say no if you don't say no to yourself. And I think it's a very important thing to mention for anyone that didn't know and for anyone that's listening, that you can request any type of medical treatment just because you feel like you need it. If you understand your body better than anyone else, even if you're telling the doctor, this is the pain that I feel, you're only telling them, but you're the one that's feeling constantly all at once.
That's right. Yeah, definitely.
And now we can jump into, I think, my favorite part of this topic, the insurance system, filing claims, working around any type of insurance. I think most people don't know how at fault actually works, not only in Georgia, in general. And we can narrow it down to, if you could explain, how does Georgia's at fault based insurance system works in a car accident?
Yeah. So the way it works in Georgia is if someone is at least 51% or more at fault for causing your injury, then you can hold them liable. Well, let me back up a little bit. If you yourself are less than 50% responsible for causing whatever led to your injuries, then you can recover against any of the other individuals or companies who are responsible for those injuries. And so the way it works in Georgia is typically we have minimum insurance requirements for drivers. Doesn't mean that drivers always comply with their legal obligations to do so, but if they are, they have a obligation to maintain at least $25,000 per person and $50,000 per incident in automobile coverage. And so typically what happens if somebody hits you in a car wreck accident and they're at fault, then you can file a claim with their insurance carrier to try to recover for the damage that was done to you. And that includes the medical bills that you incurred. That includes the pain and suffering that you have. If, God forbid, there's a death, then it can include the full value of your life is something that your family members can recover after you pass. And insurance companies will be very quick in many instances in car wreck cases to offer you a very small amount of money to get you to just go away, because they know if you hire an attorney, an experienced car wreck attorney, that your claim is going to be much more valuable. So I have clients all the time who call me and say, Progressive just called me and offered me $2,500. What should I do? The first thing I say is do an investigation. Let's see, what's going on here, because almost every single time they're trying to offer you something they know is way less than the value of your case, because they're hoping that you're not going to do an investigation. They're hoping you're not going to hire an attorney. So when you hire an experienced car wreck attorney, they do the full investigation. They communicate with the insurance carrier and let the insurance carrier know in a very advocate sort of manner what's going on with you, what's going on with your case, why your case has value. As an attorney, I'm able to speak their language. I know what they're looking for in evaluating your case. So even though you could report 7 or 8 things to me, I know how to interpret that and report that to the insurance company so that they know exactly what the case is worth, or at least give them the opportunity to understand what the case is worth. So essentially how the process works is after you've undergone treatment, or most of you have the insurance limits from the insurance company, what we typically recommend at that point is sending a demand to the insurance company. Oftentimes it's for their policy limits, because so often there are only $25,000 in insurance limits available. If there's more, then we sometimes have a discussion, maybe about a demand that's less than the policy limits, but typically we're demanding the policy limits. And the insurance company will have 30 to 45 days to either say yes to accept that demand, or they'll say at which point, typically that means you're going to be filing a lawsuit to be able to get the compensation you deserve. One thing I want to mention too, I think is really important that not many people really understand, is you have your own coverage sometimes for even when somebody else is at fault. So your own automobile policy hopefully has what's called underinsured or uninsured motorist coverage. That is coverage you buy for when the person who hits you either doesn't have insurance or doesn't have enough insurance. So let's say your case is worth $100,000 and there's only a $25,000 policy from the person who hit you. If you have uninsured motorist coverage, you can use that to make up the difference. So if you have a $75,000 or more in uninsured motorist coverage, then you would collect the $25,000 from the at-fault driver's insurance and then $75,000 from your own insurance company. So I always, before the accident, before the bad thing happens, highly recommend that you go purchase uninsured or underinsured motorist coverage. It's really cheap. Insurance companies don't like to tell you that. They don't like for you to have that coverage, but it's super cheap and it protects you in cases of where somebody else maybe wasn't very responsible and they didn't have enough insurance to compensate you for what they caused.
I think one of the best things I've learned today about knowing is that coverage is actually cheap. I think it's such a great thing to make a point of. They don't want you to know. You should go ahead and move into this. Be sure. I don't think a lot of people, well, I just learned this myself. I don't think a lot of people know the type of coverages you're able to have. I would have never realized, honestly, that there is an underinsured or an uninsured motorist type of coverage. I was just thought, okay, my car is insured, but there's so many instances of, you're right, what if I go into a car accident and the other person doesn't have insurance, which a lot of times, and taking a note of all of this different and little things that we need to do in order to protect ourselves from big insurance companies, it comes to a very interesting notice of understanding and knowing I need to have certain extra steps in order to protect myself at all times.
Yeah. And one thing in Georgia, too, about that underinsured motorist coverage is an insurance company is required, if you don't select otherwise, if you purchase that automobile policy that you mentioned, then you automatically get the amount of whatever your liability coverage is. Let's say you got the minimum limits, right? Your automobile coverage is for $25,000. Unless you sign away your right otherwise, you are also entitled per that policy to $25,000 in uninsured motorist coverage under Georgia law. What insurance companies often do, though, will try to convince you to sign a document. It's called a selection rejection form that signs away your right to that uninsured motorist coverage. And they'll tell you it'll save money, which it will save a little bit of money, not enough to make a difference. You'll save a little bit of money in the meantime. They want you to save that money on the front end because they know that they are going to be the ones saving money to your detriment when you do, unfortunately, get in that car wreck where the other driver just doesn't have insurance.
Okay, I think it's a great point to take a notice of. Just understanding all of the unfortunately, all of the different pathways that you would need to go and understand. And well, that's why we have this podcast. That's why we're talking. That's why we're trying to teach everyone here. And keeping on that line and still talking about the state of Georgia. And I think this is one of those rules that can completely change the outcome of a claim. So could you tell us a little bit about how does modified comparative rule could affect the way that you can recover from this car accident?
You said the comparative negligence rule?
Yes.
Yeah. So the comparative negligence rule is a rule in Georgia that says if sometimes it's not clear who all caused a car wreck or any other sort of injury, right? Mm-hmm. Sometimes you might have done something that led to it as well. Even though the other side might have done more, they might be more at fault, you yourself might be partially at fault as well. And in Georgia, that would reduce at a jury trial the amount that your claim is worth. So if your claim is worth $100,000 and you're 20% at fault, the other side is 80% at fault, then your claim would only be worth $80,000 because that 20% that you're at fault would be reduced from the ultimate value of the case. But if you are 50% or more at fault, you cannot recover in Georgia. So what I like to say is 50% actually equals zero. So in that same scenario, if your case is worth $100,000 and the other driver is 50% at fault and you're 50% at fault, you're entitled to nothing under Georgia law. Okay. And so it's really important. We go back to making sure we have witness statements and their information and doing a full and forensic investigation. These are all really important steps to proving that the other side was more at fault than you were. Because if you're 49% at fault, you can recover. If you're 50% at fault, you cannot recover under Georgia law.
Okay. And after going through all of that, we've been in the accident, we've determined the at fault, I'm at fault, the other person's 51. I've documented everything. I've gone to the doctor, I've done everything. Now what? Could you give us a walkthrough in a step-by-step process of in a car accident claim in Georgia?
Yeah. So even if you do everything exactly right, which is rare because, again, we're human and it's
Yes.
hard to do everything right. But even if you do everything right, the insurance company is still going to do everything they can to make your case unsuccessful. Even though it's clear that the other driver was more at fault or completely at fault, they're still going to blame you and they're still going to try to poke holes in everything that you did right. So hiring an experienced attorney is incredibly important in filing a claim, and especially if you're going to file a lawsuit. Because guess what? If you file a lawsuit in Georgia, the insurance company is going to hire an attorney to defend the other driver. In fact, they have an obligation to do that. They have to do that. It's part of the contract that they sign when they have an automobile policy. So if you're filing it alone, you're going to be going up against a very seasoned defense attorney who's representing the other side, who's going to do a thorough forensic evaluation, and who's trained to advocate for their client in a way that pokes holes in your case and makes your case more difficult. But the process is, if you can't resolve the case pre-suit, then an attorney would draft the lawsuit for you. It would include all of the allegations. In Georgia, we just have what's called notice pleading. Essentially, you have to put the at-fault driver on notice that you're filing this case against them. And like I said, then the insurance company will have to provide them a defense attorney to be able to defend their claims. In Georgia, by statute, you have 60 days of discovery after the defendant answers the complaint. And that includes things like written questions that the other side has to answer and written questions to you that you have to answer, requests for documentations. You and the other driver and witnesses will be have their sworn statements under oath before trial. And then at that stage, you might be able to settle the case again. But again, if you cannot, the case proceeds to trial where you need a seasoned trial attorney to be able to advocate for you and to explain to the jury why the other side caused the wreck, or why the other side is more at fault than you are for causing the wreck, and why it matters and why it's a big deal that you're going through and suffering what you're suffering from.
And speaking about insurance companies and the fact that we've just learned that they are legally obligated to get an attorney, is there common tactics that you feel that Georgia's insurance companies use in order to reduce or deny any type of claims that the seasoned attorney are going to be very well aware of that we as a potential client are not?
Yeah. So, I mean, in the he said, she said context, right? You're saying that you had the green light. The other driver's saying that they had the green light, and there's no other witnesses. They're going to use that tactic to say, jury, you should say it's 50-50, because they know if it's 50-50, it's actually zero, right? So they're going to use that tactic. We talked about gaps in treatment. They're going to use that as well. So anytime you're not reporting a particular injury at a medical appointment, they're going to say, well, look, you didn't complain about it that day, so it must have not been happening at that time. Again, we all know that's not the case, and that's not how humans work. But if you don't have a seasoned trial attorney to explain to the jury that this was actually happening and here's the justification for why, then they're absolutely going to use that against you and try to poke every hole they can in your case.
And within that, also the she said, I said, is there something that you should say and not say when it comes to insurance adjusters after a Savannah or Georgia state car accident?
Yeah. Again, I would recommend not speaking with an insurance adjuster without at least first talking to an attorney. I do have clients where I'll say, yeah, I think it's okay to talk to this adjuster, but let's talk about it first. Let's make sure that what's important to share. And a lot of times, again, just human nature is insurance company calls you, they ask you for a statement, your head is still spinning. Right? Mm-hmm. You're not thinking straight. You might say something that isn't actually true, not because you're trying to be deceitful, but because you're disoriented or you're confused. So I think it's important to take a deep breath. You can be respectful, but tell the insurance company, hey, I don't want to give that statement at this time. I want to take a deep breath and really make sure that I understand what happened before doing it. But I would always recommend talking to an attorney before you give that statement, just to make sure that you're not saying anything that would hurt your case.
And moving that towards giving up a statement, when it comes to evidence, for example, what type of evidence beyond pictures, video, medical records could make or break an accident claim in Savannah?
Yeah, when it does come to linking up these injuries, so let's say you have a herniated disc in your back, which is there's the squishy stuff in between your vertebrae. When that gets sort of pushed out, it'll sometimes impinge a nerve, and that's what's causing your pain, right? You can come to trial as a person and say, I have leg pain, but you can't say it's due to a herniated disc that was caused by this accident. You have to have medical experts who testify to that. So that orthopedic surgeon that you visited, oftentimes that's going to be the person who has to testify on your behalf that this car wreck, this traumatic event, is what caused the herniated disc. And so you have to have medical causation testimony. That's very important in these cases. If there's a dispute as to liability, oftentimes you need an accident reconstructionist expert. Okay, and there's like with any profession, there's really good accident reconstructionists and there's really bad ones. So it's important to find the right expert who can recreate the scene. And when it does become this he said, she said, sometimes there's objective forensic evidence that an accident reconstructionist can take and say, well, actually, this person can't be right, the at-fault driver, because this piece of evidence shows that the wreck happened in this way. And so having those experts, at trial is super important in a Georgia car accident case.
And what about the medical records that we're describing? Having all of that, could they also affect the car accident when it comes to, let's say, what if I had a past injury? It's now being affected by this new car accident. Is there a way that this could affect my claim?
Of course, insurance companies and defense attorneys love to talk about pre-existing injuries, even when they have nothing to do with what happened to you. Sometimes you might have gotten in a car wreck in the past and had a neck injury. And even though in this current car wreck, you have a back injury, they're still going to try to say that back injury was caused from the last wreck. Another thing they like to do is talk about what's called degenerative disc disease. By the way, I'm 37. I'm pretty young. I have degenerative disc disease. Almost everyone over the age of 25 has it, but the defense likes to confuse juries by saying that is what's causing your pain, this degenerative disc disease, without having an attorney who understands that even when you have that quote unquote pre-existing condition, it's not until a trauma, a car accident, where that condition becomes problematic and painful, right? And it exacerbates that issue. And that's when you have a herniated disc that you didn't have before. So you have to have somebody who is able to understand and explain to a jury that just because you have a pre-existing injury or a pre-existing condition, that doesn't mean that your surgery wasn't the result of the car wreck. That doesn't mean that you had pain that's the same or any pain at all before the car wreck happened. So you have to be able to explain to a jury the difference between those two things, which, only seasoned trial attorneys, I think, are able to do.
That makes a lot of sense. That specific word of a seasoned trial attorney would know how to manage all of those situations. I think this is a part where we can go ahead and jump into deadlines, courts, and legal process, especially since we've mentioned all of the legal aspect that's come before, but about during, when should someone decide to settle a car accident claim, for example, versus filing a lawsuit? Make an offer. Now there's the real decision to make. What would it be?
So it's a good question, and my clients always want to know the answer to this question. And unfortunately, the first answer is really that it's impossible for me to say when's the right time to settle a case. I will give you advice when I think it's reasonable to settle a case, but ultimately that's up to my clients. And I always am very careful to say that I want what's best for you. I want what's best for your claim, and I want you to be happy with your settlement. So if you tell me that this isn't enough money, and you want to file a lawsuit or you want to go to trial, that's what you hired me to do. And that's what we're going to do. Or if I say, listen, this isn't enough money, I don't think you should take it, but you say, I'm tired, it's time to settle this case, I want to move on with my life, I'm going to be with you on that decision too. But typically, what we want to do is we want to know the full medical picture first. We need to know what the insurance limits are. We need to know all these different things because unfortunately the question is not, what is the value of your pain? The question for a jury is, what is the value of your case? Which takes in a lot more factors than just what you're paying. Those things of pre-existing injuries that we talked about earlier, that comes into the evaluation. What county you're in. If you're in Chatham County versus a different type of county, your claim might be worth less because different jurors in different areas operate in different ways. So you have to have somebody who knows what they're doing at trial and who's actually tried cases, because they're going to take into account all of these factors: the venue, pre-existing injuries, what your medical records show, to be able to advise you what is reasonable. But ultimately, it's the client's decision what is reasonable to them, whether to accept or to reject an offer that's on the table.
Okay, that makes a lot of sense. And how long do you have to wait or file that car accident? What happens if there is a deadline and we miss it? Would that also come into effect within our claim and settlement?
Yeah, good point. A couple of really important deadlines to keep in mind. The first, and the one that most people are aware of, is what's called the Statute of Limitations. That's going to be different from state to state. In Georgia, you have 2 years from the date of the accident to file a lawsuit in most instances. There are some small exceptions that would cause that to be longer than 2 years, but you want to make sure that 2 years is the date that you have your mind on. In South Carolina, it's 3 years. In other states, it's 1 year. So that's one of the most important dates to keep in mind, is you have to file a claim within that 2-year period. Another really important deadline that most people do not know, it happens much quicker though. We talked about uninsured motorist coverage earlier, right? When you have that uninsured motorist coverage, that's a contract with your insurance company, right? Oftentimes what they will put in that contract is a duty to notify them of an accident within a certain amount of time. It could be 30 days or 3 months or 6 months or 1 year. And if you don't notify them, then their contract will say that they don't have to cover you for the insurance that you purchased. Okay. So I always, as soon as an accident happens, notify your insurance carrier, because whether that contract says 30 days or 3 months or 6 months, if you just go ahead and call them as soon as you can, then they can't say that you didn't notify them. And so notify them, set up a claim, make sure that they do it, or hire an attorney to do that for you, by the way. That's another way you can handle that. That's a super big one that a lot of people don't know about. And I have clients sometimes who come to me, a year and a half in, and they might still have a claim against the other driver, but their uninsured motorist coverage might not apply because they didn't notify their own insurance carrier. So that's a really important deadline. Other deadlines are a little softer and not as important, but the two most important things that everyone should know about is the notification requirement deadline for their own insurance and the statute of limitations deadline, typically 2 years.
And specifically in Georgia, where the deadline could be extended or shortened?
Yeah. So the short answer is yes, there are exceptions. I would never rely on those exceptions, though, because they're super tricky and nuanced. I'll give you an example. There's law in Georgia that says that if someone is cited at the scene for a traffic citation, that until that citation is resolved, till they go to court, it stays the litigation, meaning it adds time to your 2-year statute of limitations. So if it takes them 3 months to pay the citation, then you have 2 years and 3 months to file a lawsuit. The reason why I don't like people to really rely on that is, though, it's very nuanced. It doesn't always work that way. Recently, there was an opinion in the last couple of years with our appellate courts that says that only applies for the person who was in the accident themselves. If you die, for instance, in an accident and your family has the right to bring the claim, the family doesn't get the benefit of the 3 extra added months. They have to file within that 2-year period. So that's why, while yes, there are exceptions, stick to the 2-year rule for statutes of limitations, because you're never going to get in trouble filing before then, but you could get in trouble filing after the 2-year period, even when it seems like there is an extension that's applicable to your claim.
That's such an interesting wordplay when it comes to it covers the person involved. And like you said, okay, I died. I'm still involved in the accident. I lost my life due to it, but my family cannot claim that specific extension on my behalf.
That's right.
I'm technically no longer here, but it's such a little things that, like we mentioned, a very seasoned attorney could let you know. This comes while it may look like a benefit, it comes with such little details and wordplays that unless you understand what you're doing, you're not going to be able to fully take it on. I would have never guessed.
And the insurance companies want you to make that mistake, by the way. They want you to feel like you have more time than you do. But as soon, if you miss it by a second, I promise you that they're going to file motions in your case to dismiss your case without ever getting to a trial and without ever compensating you.
What a hard situation to be in, honestly. I feel like it's such an important thing to understand and know your attorneys who are going to really put in the work for you when it comes to insurance companies. It's such a back and forth. And this comes to a question that also I personally have. When it comes to claims, what would happen if I was partially at fault in an accident in Georgia? A lot of people assume that if I'm partially at fault, I can't do anything because I also have, a part to blame in this situation. Is there something that we could do or any specific steps that we could take?
Yeah, even if you're partially at fault, you can still recover under Georgia law. As long as you're not 50% or more at fault, you can recover. If you're 50% or more at fault, you cannot recover under Georgia law. But if you are 49.9999% or less at fault, you can actually recover, but it would reduce the amount that you would be able to recover. Back to the example of if your case is worth $100,000 and you're 20% at fault, then that 20% would reduce the amount of your case worth from $100,000. 20% less than that is $80,000. So your case would only be worth $80,000 in those instances. And I'll actually share, this wasn't a car wreck case, it was a medical malpractice case, but I tried a case where comparative fault was a big issue in the case. And we explained to the jury, it was very hard. It was a medical malpractice case where my client unfortunately committed suicide after seeing the doctor. And so they blamed my client's son, who had passed, for his own death. We acknowledged that he played a part in his own death, but that the doctor was the person who was supposed to take care of him and did not. And we explained to the jury, if you say it's 50-50, what you're saying for the doctor is he doesn't bear any responsibility and that my client can't recover. That jury came out 51-49 in our favor, which was a big statement for the jury because they were saying, yes, we understand that your client bore some of the responsibility, but we don't want this doctor to go off scotch-free because we believe he did something wrong and should have to pay for it. Mm-hmm. So you've got to have a good attorney if you're at all at fault, because only really good trial attorneys who have tried comparative fault cases understand how to explain that to a jury to ensure that you're able to succeed at trial.
That makes a lot of sense, I think. And it's such an important thing to mention. I've heard a lot of stories about people essentially losing money, time, life, having to suffer through such a harsh medical situation because a lot of us don't really know that even if I am partially to blame, I can still protect myself and I can still work around this. And interesting follow-up question. I may be at fault. Other person may be at fault. What if I'm not at fault, but the other person flees the scene that I'm protected from in Georgia?
It depends, right? Unfortunately, there are instances where you won't be protected in those scenarios. I've had cases where someone's fled from the scene on multiple occasions, actually. Sometimes, fortunately, the police catch up to the truck driver who hit them or the other car driver who hit them. And that's a really good thing because now you have somebody who clearly fled from the scene, and you could be actually entitled to more money in those cases because that would potentially entitle you to, a claim for attorney's fees, potentially entitle you to a claim for punitive damages. So if they're able to catch that person, that's a great thing for your case. But it happens so often that they're unable to catch that person. In those circumstances, there's really two options. You can investigate yourself and try to find that person. You can request records from nearby gas stations or businesses who have cameras and try to find the license plate. I've been able to do that before. And so in those instances, again, you're going to be protected if you have the right attorney, the right person investigating your claims, because they're going to be able to find this person. But there's sometimes where there's just not evidence. You can't find the video. The police aren't able to catch up. In those instances, you can't hold that person responsible because you don't know who that person or that company is, which again is why it is so important to have uninsured or underinsured motorist coverage. In that instance, just like when somebody doesn't have insurance, if you don't know who hit you and they fled from the scene, then the only way that you're going to have protection to be able to compensate yourself is through your own insurance. And so it is super, super important that you purchase uninsured. Again, very cheap uninsured motorist coverage.
Should I just go ahead and get my uninsured and underinsured?
Yeah, absolutely. Yeah, you better.
Could you imagine? I'm here in the podcast interviewing you and I'm thinking, I'm not going to get it. That would be such a stupid decision on my part.
Yeah. Well, I still get it. And listen, I especially get it right now. We're in times where eggs and gas and all these important life things are super expensive. And uninsured motorist coverage might not be your main priority right now. And I can certainly understand that. If you can manage it, though, absolutely purchase it.
Definitely. And I think it's such a great thing, and it speaks volumes of, we understand how the economy is. We understand everyone has different situations, but if you are able to, definitely. There's a lot of legal help, common mistakes in Savannah or Georgia's very specific factors that comes to a situation that nobody really thinks that they're going to get into. No one wakes up and thinks, I'm going to get into a car crash today. I have this type of coverage. But life is such a volatile thing in general that if you are able to do it, most definitely. No one ever really thinks, I need the information and the knowledge of really good car accident attorney. Because we never really think when we get out in the morning, go to our commute to work, this may happen. When it comes to the situations, when should someone seriously consider hiring a car accident attorney? A lot of people are not really sure if the case is big enough to justify calling a lawyer or having a lawyer or even considering.
Yeah. I think you should, from the very beginning, at least consult with an attorney. Doesn't mean you have to hire them. And what a lot of people, I think, don't understand, I realize this, especially in my home community here in Savannah. I've had clients tell me recently that they were hesitant to call me until someone explained to them that calling me doesn't cost them anything. Right. I evaluate cases every day. And sometimes I do say it's not a case for me, or maybe it's not a case at all. And that's okay. You don't lose anything by getting an evaluation by an attorney who's going to do a free consultation. Most people can't afford to pay the high per hour rate of an attorney. And so I exclusively work on a contingency fee basis, which means the only way you pay me is if you're successful in resolving your case and you're paying yourself first. Right? You never have to pay me until the case is over, until there's actually money coming in to be able to pay me. I take a percentage out of the recovery. I also, if I decide to take a case, or even before I decide to take a case, if I'm investigating a case, the expenses that go into that, hiring experts, driving out to the scene, recreating the scene. If for whatever reason you're unable to recover down the road, I never ask you to pay those costs back. Those are costs that I just eat. So it's never going to hurt you to speak with a personal injury attorney such as myself, because we're going to give you our honest opinion. We're going to do an investigation at our expense. And ultimately, if you're unsuccessful, you don't come out of pocket any. But if they do decide to take your case, you're going to have somebody in your corner who's going to be able to advocate for your claims and increase the value of those claims that you have. And again, you're only paying them once you get paid yourself.
Thank you very much for explaining that contingency fee. I know it's a very important thing for our listeners and potential clients to know. I don't think a lot of people knew, myself included when I started in this area, that a lot of personal injury attorneys work on that contingency fee to give that sense of security to people. Most of the times, for example, if it's a car crash or an accident big enough, what if I cannot go to work? What if I'm not making money? I have medical expenses, I have car expenses. I may be the head of my family and I have a lot of more expenses. And some people feel a little shaken and unsure of, but what if I don't win? What if this happens and I'm still paying? It's a pile of billings and situations like this. So I think it's such an important thing that you mentioned right now in the open, that you work on contingency fees. And I think that's something great to notice when it comes to choosing your attorneys. And could you also give us any other advice of what should someone look for when choosing a personal injury attorney? Do you feel like makes people choose you, for example?
Yeah, so that's a great question. The one thing I would say is don't just call the first person on the billboard or the first person on a TV. It's okay. There's good attorneys that work at these firms. I'm not saying that you can't hire a billboard lawyer or a lawyer on TV, because like I said, there certainly are good attorneys who work for these firms. but do your research. This is an important decision. This may be the only time you ever bring a claim in your life. And so do your due diligence. Before you hire an attorney, talk to multiple attorneys, frankly. I've oftentimes had people come even meet with me and they had questions about things. I said, go research other attorneys in the area, but go look online, look at their results. If you go to my website, connlawfirm.com, you go to the results tab, you'll see actual results of cases that I've actually litigated, that I've actually tried in many instances, or if we didn't try them, we settled them for a lot of money before a trial because the proper workup went into it. You'll see 8-figure type results, 7-figure type results, and sometimes 6-figure type results on my website. And these are all things that I've handled myself. And so research the actual attorney, not just the firm, right? Because a lot of these big firms might have some attorneys who have some really big results, but the person who's representing you might not have ever tried a case. Or maybe they've tried cases, but they've only lost. So really do your research. Make sure that you're hiring a real trial attorney, not someone who's just going to try to do the bare minimum and settle your case quickly because they want to make a quick buck. Find somebody who's going to go to bat for you, fight the insurance companies, and get what you deserve.
What a great advice. No comments. I 100% completely agree. And it was interesting that you mention the litigation. What does a litigation process look like for a car accident, if a car accident does go to trial?
Yeah, again, it depends on the type of case. Some cases are more simpler than others. Some just requires depositions of you, the other driver, and maybe a medical professional. Other cases are more complex. There's a lot of witnesses involved, and they're medical experts and accident reconstructionists, all these different things that go involved. Every case is a little bit different. But again, you have to have someone who's actually experienced in litigating cases to be able to decide what is best for the case, which witnesses you need, what experts you need. But again, typically in Georgia, a car wreck case, the litigation takes about 6 months to a year. It can last longer. It can be 1.5 to 2 years. And sometimes we're at the mercy of a judge for getting a trial date. So even though you do all the work in 6 months, you might have to wait 1.5 years to get to trial, not because your attorney's not doing the right thing, but because the court is just too overloaded and can't set you for a trial in time. But the trial process, it can be grueling on the person who has to go through it. But I'd highly, again, recommend lean on your attorney in the litigation process. They're going to help you understand, what that process looks like for your particular case. They're going to be able to make the determinations of who they need to hire in terms of experts and things like that.
Very interesting notice. Very interesting. I think my main objective of this is it's such an important thing to, like you said before, do your research, understand your attorney, and have someone like Andy Conn letting us know at all times what the steps are, what the connection is, and just someone that is going to be upfront, clear, and honest with you at all times. And if we can take something out of this episode for someone listening right now who has just been in a car accident in Savannah, what is the one thing that you would like them to remember?
Well, first of all, to any of those people listening, I'm sorry that you're going through this. Even the quote unquote small car wreck cases aren't small to you, and they're very scary, and there's a lot of questions you might have. The one thing to remember though is no matter what happens, whether you think you've made the right or wrong decisions, you can fix it. And there's an attorney. If you get the right attorney involved, we'd love to represent you, but even other seasoned attorneys in the Savannah and Chatham community, if you get the right person involved, they're going to be able to fix any issues with the case or help walk you through that process. And so know that you've got resources available, again, that are free until you actually have a recovery that can help walk you through that process so that you can focus on getting better and let your attorney focus on the legal side of things.
And just to put it out there, that first initial consultation, that's free, right?
That's free. Yeah. Again, everything that you go through on a contingency fee basis is free until there's a recovery. So even if it takes 5 years for whatever reason, and we're hiring experts and Conn Law is spending a lot of money on your case, you're never spending a dime unless and until there's a recovery. And and at that time, you're actually making money.
Well, you heard it here, folks. If you have ever been in a car accident or have recently been in a car accident in Savannah, you're not sure what to do next, make that call. You can go ahead and find specifically Andy Conn at connlaw.com or connlawfirm.com. Or you can go ahead and give him a call directly. We are so thankful, Andy, to have you here. So thankful for everyone watching. We will hopefully see you in the next episode to our viewers of the Conn Law Firm podcast. It was a pleasure, Andy, to be able to more about your work, learn more about you, and for you to give us all of your honest and amazing answers to all of our questions and the need to understand what to do when it comes to a car accident.
Absolutely. Thank you for having me. I appreciate it.
It was a pleasure. Thank you, everyone, for listening. My name is Anna, here with Andy Conn. We hope you have a great day.